We now move on to consideration under the formation of a contract. In this session, we cover the following topics. We look at what is consideration, what is the definition of consideration. We then consider some rules around consideration, that consideration must be sufficient, consideration cannot be in the past. We consider the performance of an existing public duty and the performance of an existing contractual duty. And we end with part payment of a debt and promissory estoppel. You will all be familiar with the key elements of a contract, and I'm not going to go into much detail here, except remind you that, of course, for a valid contract, you need to have all these 4 requirements. Number 1 is capacity. Number 2 is offer and acceptance, which equates to agreement. Number 3 is intention. And number 4 is consideration. And of course, we are looking at number 4 in this session, consideration. So let's consider what is consideration, a definition of what consideration is. Now, consideration can be anything of value, which both parties, the promisor and promisee, must agree to exchange to have a legally enforceable contract. Say, for example, A could promise to sell his car to B in exchange for £100. In contrast, if A was to promise to give his car to B without requiring anything in return, it is referred to as a promise not supported by consideration, otherwise known as a gift. And no matter how much the parties to the contract may wish it to be legally enforceable, it will not be so unless it contains consideration. You should note that there are some situations where promises are regarded as enforceable even in the absence of consideration, and that is known as the doctrine of promissory estoppel, which we look at further on. Let's now consider the definition of consideration. Now, consideration was defined in the case of Curry Mesa, 1875. The definition was: a valuable consideration in the sense of the law may consist either in some right, interest, profit or benefit accruing to one party, or some forbearance, detriment, loss or responsibility given, suffered or undertaken by the other. It is sometimes said that the consideration requires benefit and detriment, but this is not necessary for the formation of a contract. In other words, what is provided by way of consideration should be a benefit to the person receiving it or a detriment to the person giving it. Sometimes both are present. For example, in the contract concerning the selling of the car, B is suffering a detriment by giving the £100 and A is gaining a benefit. B is gaining the benefit of the car and A is suffering the detriment by losing it. Therefore, in most cases, there will be both benefit and detriment present, but it's not essential. Another example, A agrees to give the car to B if B pays £100 to charity. In this case, there is a detriment to B in giving the £100 to charity, but to the benefit of A. Regardless, there is good consideration and therefore a legally enforceable agreement. So let's consider, can a promise to act itself be good consideration? Now let's consider this question over the next few topics. In the case of Dunlop, Selfridge and Co. 1915, it was confirmed that a promise to act can itself be good consideration. Lord Dunedin stated in this case, an act or forbearance of the one party or the promise thereof is the price for which the promise of the other is bought, and the promise is thus given for value is enforceable. Therefore, a promise to transfer, consideration is often sufficient, and further benefit and detriment are not so much essential elements of consideration as necessary consequences of its performance. Let's now move on to consider the various rules of consideration. Really important this slide is here, the rules of consideration. The consideration must be sufficient. Consideration must not be in the past. Consideration must be of value. And finally, it can sometimes exist through the performance of an existing duty. Let's consider these further. Now, the first recognised rule in relation to consideration is that consideration need not be adequate, but must be sufficient. It must have some economic value, which may be negligible. The courts will generally not inquire into the adequacy of the consideration, provided there is some element of consideration present. Now, the adequacy means whether what is provided by way of consideration corresponds in value to what it is being given for. So, provided something is given in return for the promise, it is irrelevant that it may not be much or equate in value, or what it may be considered to be worth. For example, in the contract concerning the selling of the car, what if I said the car was a brand new Ferrari? A brand new Ferrari is valued at far more than £100. However, the transaction will still be binding because some consideration has been provided by both sides. Further, consideration must be something which is of some value in the eyes of the law. Let's consider the case of Thomas, 1842. Here the claimant was a widow whose husband had stated that if he died before his wife, she would be allowed to live in his house for the rest of her life, after which it was to pass to his sons. When the man died, the defendant, who was his executor, agreed that the widow could continue to occupy the house in return for a promise that she would pay £1 a year and keep the house in good repair. Despite this, some time later, the defendant tried to evict the widow. So she sued for breach of contract. Now, the defendant claimed that the earlier promise was not binding because of a lack of consideration. However, the court held that the widow's promise to pay £1 and keep up the repairs was sufficient consideration to make the owner's promise binding. Now, this legal principle derives from the idea of freedom of contract, in that parties are typically free to bargain on whatever terms they wish, and that courts are unwilling to interfere with bad bargains. As we have seen in Thomas, consideration must be something which is of some value in the eyes of the law. This generally has been interpreted to mean that it must have some economic value, even if such economic value is negligible, i.e., it must be capable of amounting to consideration. Now, this rule was further demonstrated in the case of White Blut, 1853. In this case, a father waived a debt owed to him by his son, in return for his son stopping complaining about his will. When this situation was reviewed by the court, it was found that this was not valid consideration. An agreement to not complain in this instance was viewed as not having any economic value. Let's now consider a further key case under this rule, the case of Nestlé Company Limited. So, past consideration. The question to ask yourself here is whether the consideration was given in exchange for the other party's consideration. Now, consideration must be given in return for the promise or act of the other party. So, if one party has completed performance before the other party offered consideration, then it is unlikely that the earlier performance was done in return for that consideration. As we know, with past consideration, consideration must be given in return for the promise of the other party. Now, the authority on this is the case of Roscola Thomas, 1842. Here the defendant sold the claimant a horse. After the sale was completed, the defendant told the claimant that the animal was sound and free from any. A more recent example of this approach was considered in the case of Re McArdle, 1951. Now, with all that said, the courts have recognised some situations where a promise made subsequent to the performance of an act may nevertheless be enforceable. One key common law exception is where the past consideration was provided at the promisor's request, and it was understood that payment would be made in return. This derives from the case of Lampley Braithwaite, 16.